you're kind of nervous coming in here. You're going to talk in front of a bunch of people, trying to get your confidence up. So I came in and saw Mike, and he said, "Oh, this is great. We got a sellout. This is the best crowd we've had in a long time." So I'm getting my swagger, feeling good. Everybody's coming to see me, but quickly, right after that, Susan Kastner comes up and says, "I really know what you do, so I'm going to sit through what you're saying because I'm really here to listen to Marshall Pickens." It looks like you're the star of the show. So I'm just warming you up. I think this quote is very appropriate for what I do. The challenge with special needs planning, I think, is getting people started a lot of times. And you've got brochures on the table, and I also think our brochures are appropriate. The title of the brochure, Beyond One Day at a Time. What I find with financial planning, with estate planning, and especially with special needs families, is that it really is one day at a time, just trying to get to the next day. So carving out the time and the energy to do this extra planning that you really need to do, and I'm going to try to educate you on that some today. It's really hard to get people to the table, but once you get them to the table, they understand what needs to be done. A lot of times there's a lot of success. So the hope for me is, with all of you professionals in this area, that if I can help you understand some of these issues a little bit better, the word just gets out and people understand more what they need to do. So I thought these statistics were a really good way to start, and really an eye-opening way to talk about this. When you talk about estate planning or special needs planning, you can kind of see the numbers. 68% special needs families have not written a will, 53% have not identified a guardian, 72% haven't identified a trustee, 88% have not created a special needs trust. And as I think most people in here know, that is so critically important to protect government benefits for the special needs children. And then we'll talk a little bit more about a letter of intent shortly, but it is a really good document to add to your estate planning, and you've got an example of it in that folder. I'll pull it out in a few minutes. But it's just something that you can really talk about your child's interests, special needs, things that are very important to them, or medications. All these things about your child are not going to be in a will. They're not going to be in an estate planning document, but a letter of intent is a great document to be able to list those kind of things. So, with our process, it really starts out with a discovery session, okay? It's sitting down with folks and asking these kinds of questions, not only financial related questions, what are your savings habits, how much have you saved for retirement, but also about their vision for the future, for their family, individually, financial goals, personal goals, business goals. Really, I can only do a good job with respect to their planning if I really know what their vision and goals are. So I'm really trying to figure out a lot of things about them and their family, and particularly in a special needs situation, I'm asking a lot of questions so I can know as much as possible about the child, what the needs are, etc. So that's a really important part of the process of what I do with special needs planning. So this really covers the whole process, whether it's a financial planning client or a special needs financial planning client. Really the process is very similar. There are just additional or a few different things that I would do with a special needs family that I wouldn't do with other families. But again, and Dana warned us that there's a ghost in this screen, so about every minute or two I think it just flickers. So after we have that discovery process, what I do is really try to put together a plan that is very specific to an individual situation. So it's not a cookie cutter process. It's all driven by the discovery, the questions that I've asked, the information that's been gathered about their situation. And really, it's financial security planning. And that's an important term because it's what I'm trying to do is make sure that entire family is financially secure. And that's really about a number of different things. So it's wealth preservation and distribution, and a lot of this is the estate planning. So when we're talking about planning for a special needs family, that's usually a very huge part of making sure we get their estate planning done correctly, the proper trusts are in place. We'll talk a little bit more about that. Wealth accumulation is really the savings component, so whether it be saving for retirement, saving for education, and then risk management is what if something unexpected happens. So yeah, let's talk a little bit more about the wealth preservation and distribution aspect. So part of that, obviously, I think that a lot of people are aware of is just you really need to have a will, okay? The problem, especially once you have children, if you don't have a will, state law controls how your assets are distributed. And I think most people, if you ask the question, they would say, well, I'm sure if I'm married and I have 2 children, if I were to die, state law would probably say everything just goes to my spouse. Well, that's not accurate. What state law says, if you have children, if you have no children and you're married, state law does provide that everything will go to your spouse. But if you have children, and you don't have a will, and you pass away, state law says half of your assets go to your spouse, the other half are supposed to be distributed and owned by your children. So it would be split up amongst however many children you have. So obviously, depending how you own your assets, that could be a house, that could be a car, that could be an investment account, a savings account, anything you own in your own name, that becomes real problematic if you have minor children or a special needs child. If you have a special needs child, it becomes problematic on multiple points. That could be assets that go to that child that eliminate their government benefits and are really problematic. So trying to explain why it's critical to have a will regardless, but especially when you have a special needs child, it's critical. Trusts are a big part of this as well. When you have minor children, typically you want to have trusts in place. So if you're a single parent, if something happens to you, or if you're married and something were to happen to both parents, in your will you need to have some trust there for the minors. That would be called a testamentary trust. So it's a trust that would only kick in after you passed away. And it would be a trust that could be managed by someone you name as a trustee on behalf of your children. Again, whether it be minor children, a special needs child, or quite frankly, just an irresponsible child who would spend the money quickly. Those are reasons that you may need to have a trust. Now, there are many other reasons to have a trust. 10 to 15 years ago, it was a lot more likely for a lot of people to potentially have estate tax issues. Now, the exemptions for estate taxes have gone way up. So there's less reasons now to have trust for estate tax reasons unless you're quite wealthy. But having a trust for either a spouse, children, or special needs children, all are reasons to think about having trust as part of this estate planning process. The other part of it that is critically important, again, whatever your situation may be, that a lot of people don't think about, they think about wills and maybe trust, powers of attorney. So these come into play typically come into play if you're incapacitated. So you get sick or injured and you can't tell people what needs to be done. You're incapacitated. You have to need to name somebody to be able to make those decisions for you and handle those things for you. And the way you do that is through a power of attorney. So there's a healthcare power of attorney, which in today's world of HIPAA, as a lot of you are well aware of, you need that to be able to get medical records, to be able to give guidance to the medical professions for what to do on behalf of the person who's incapacitated. The other one is a financial power of attorney, or what's called a durable or financial power of attorney. So again, those are for accounts, business decisions, any of those sorts of things. So you can give either a family member, a spouse, whoever that person you trust is, you can give that person the power to make those decisions if you were ever in a car accident or got really sick and you couldn't handle those things for yourself. In the world of special needs, the big issue on power of attorney is a lot of times power of attorney versus guardianship. So you have a child who reaches that adult age, and which way do you go? And a lot of times that depends on the severity of the issue and whether that child has capacity. In my opinion, if the child has capacity to understand that they're giving a power of attorney to their parent or family member, that is a great way to go, because you don't want to take away all of their rights, which is basically what happens in a guardianship situation. The parent or the family member who becomes the guardian is taking away their rights. Sometimes the special need is so severe and there isn't the capacity to understand that, hey, I'm giving this person this power of attorney. So there are situations where that guardianship has to be done, but there are a lot of situations in special needs cases where it can be a power of attorney. It's a much less expensive process. The whole guardianship process requires multiple attorneys be hired, go before a probate judge. So it's a much more sophisticated process, and obviously it's going to be more expensive to do that. But the important part, especially when your child is 18 and beyond, if you have a special needs child, is you need to do one or the other to protect those rights and interests. So, that's a discussion I'm having with a lot of folks that are coming to sit down with me. It's getting these things in place, and if their child is of that adult age, until they're 18, you've got all the power as the parent. But once they're 18 or beyond, then it's a whole different conversation. Also, when you think about benefits, I'm not going to talk a ton about benefits, but when you think about the benefits, if your child has benefits, it's typically Tefra Medicaid until age 18. Then you go into the world of Social Security and Medicaid. So everything changes. A lot of things change at 18. So I'm always happy when I have folks come to see me when their child may be 16 or 17, and we can do these things as that time is approaching, rather than if the child's already 25 or 26 and we've already been there for a while. And the other big thing, beneficiary designations is a part of the estate planning process. And again, it's about being very careful when you have a special needs child, particularly being very careful in how you complete those beneficiary designations. So that would relate to a life insurance policy, an IRA, a 401k. Both life insurance and those kind of qualified retirement plans, they're non-probate assets. So if you name a person in the beneficiary designation, that's not going to pass through the probate process, but it's critical when you have a special needs child of how you do that. Because if you don't fill those things out, again, by default in certain situations, assets can go directly to a special needs child that would put those benefits at risk. Okay? Wealth accumulation, another part of it. That's really the savings component, saving for retirement. I'm sitting down with people, and this particularly applies in special needs planning situations. I really have to work with people because, again, they get this one day at a time mentality, and maybe they start focusing not on saving for retirement and doing the things they need to do. So a lot of times it's an eye-opening experience that, hey, we've still got to do these things for your financial independence, for your own retirement. So we talk about tax-efficient ways to do that, different vehicles you can use, 401ks, IRAs, Roth IRAs, many different vehicles that can be used just depending on your particular situation. And again, when you think about an adult child, so an adult special needs child, a parent may be getting up there in 60s, 70s, or whatever. That's when we really know that, hey, that child is going to be here for a while after I'm gone, and maybe they're not going to have the traditional retirement, but they're going to need funds to take care of their needs long after I'm gone. I'm going to take care of my child as long as I'm on this earth, but when I'm gone, then we need some things to take care of them. And there are only certain assets you want to leave, and you want to typically leave them in a trust. So naming the child the beneficiary of IRAs, 401ks, there are tax and trust issues with that. Those are not good vehicles. Second to die life insurance or life insurance on a single parent is a very good vehicle because it's tax-free, pays in a second to die situation. If there are two parents, it only pays after the second parent passes away. But you handle the beneficiary designation correctly, and it goes right into that special needs trust that you should have already had in place. So that's often a way that you can fund a special needs trust. And there are other assets that you can fund it with as well, but those are a couple of examples of why you need to be really careful when you think about what should I leave to my special needs child, because some assets can be really problematic. Saving for education. The traditional way to save for education is a 529 education plan. Now, I have a son who's 12 years old. He's on Tepper Medicaid, but we highly feel he's doing really well, and we think he's going to go to college. And I was an estate planning attorney for 9 years before I started doing financial planning. So I have a background in that area. But I've been very comfortable myself putting money in a standard 529 plan for my son, even though he's on Tepper Medicaid, because I understand that because he is the beneficiary of that 529 plan does not make him the owner of that 529 plan. So the issue is if you own an asset. Now there are paranoid attorneys and accountants that will tell you let's just stay away from that. So I don't have a problem with that if you want to be really conservative. But we fill out the Tepper Medicaid forms every year. They've never asked about a 529. So if they're not asking about it and they're asking about all these other things, I'm not overly concerned about it. But if we are concerned about it, or if we're not sure whether our child is going to go to college or not because of their situation, the newly formed, I guess, newly approved and just being approved state by state, the 529 ABLE accounts are something that you can use for the very same purpose because you may just not be sure and you don't want to lock it up, because if you put it in a regular 529 education plan, you really want to plan on using that for college or grad school. Okay? Because if you don't, there are going to be penalties and there are going to be taxes. So money that you're putting in a regular 529 education plan, you really want to be pretty sure you're going to use that for college or grad school education. So if you're uncertain, now with the 529 ABLE account, that can be a place where we can put money away. And I want to go ahead and point out, this should be coming on the e-blast, right, Mike?
Yep.
So it will be coming out soon, but we've been trying to stay updated on the ABLE accounts. And in your packets, it should be right on top, right? This is kind of an update article on kind of what's going on in South Carolina. And it also talks about the other states literally in the months of July and beginning of the months of June and right at the beginning of July who have just started opening their accounts. So Ohio was the first one, and Florida, Nebraska, and Tennessee have followed. So we're just starting to see the states actually get these accounts in place. And I think we've talked about this before, but because you're in South Carolina does not mean you have to wait for the South Carolina plan. You can go across state lines and use another plan. But you just want to understand how those plans work, what their investment options are, because you can invest that money and hopefully over time make some return on that money. Okay? So, and by the way, if any of you have questions, feel free to pop your hand up or ask the questions as we go, and I'll try to give a few minutes as we finish also. But that's kind of an update, so you can read just a little nice one-pager here. And we also had an article I did when they were first approved back in January of last year, I think, kind of when they were first approved, but they had to go through the political process in every state. And we also we loaded you up on 529 ABLE information. This one-pager is a great piece that kind of shows you what you can spend the money on, the limitations, the $14,000 a year limit on what you can put into it, $100,000 maximum on what you can have in the plan total. So this infographic is a great one piece where you can quickly get the summary of the rules, regulations, etc. Okay?
Is that different state by state? Or is that the...
No, generally it's not going to be. These are mostly general rules, but you do need to know if you're going to go outside to another state or ultimately South Carolina, you do need to pay attention to what the rules are. So they provide good website information. You know, everything seems to be website anymore. So what we've seen with the other states is they're getting it out on their website and they're explaining exactly how they work, what the investment options are, what the limitations are. But this gives you a real good the general rules that typically they're not going to waver much off of this. But every state kind of can make its own rules. Okay? So that's really the wealth accumulation piece. Ooh, this goes fast. risk management. There we go. Really, that's the unexpected death, or and really you're thinking about the parents. We've got a special needs child, and we're taking care of that child. Maybe one parent's working, the other parent is taking care of that child. So if we have an unexpected death, disability, illness, injury, where somebody can't work or somebody doesn't make it home, that's going to be extremely problematic. So all I'm saying there is part of the planning process is, again, not just to plan for the child's future, but to make sure the parent or parents are taking care of everything on their end as well. So it ends up a lot of times starting out with a focus on the child and getting that estate planning in place, getting those things in place, but really branching out and making sure in a comprehensive fashion that the family has done their financial security planning for the whole family and not just for the child. And I really think when you talk about implementing the plan, it really does take a team. So a lot of times I end up, if they come to me first, a lot of times I'm starting the process. So I'm kind of the quarterback, if you will, and I'm pulling in other specialists, either on the government benefit side, either local specialists, but we've also got a group that we have a partnership with that I did put a brochure in your packet, and they're a national consulting special needs group, small business, but they do consulting nationally, so they work all over the country, National Care Advisors. So we have about 30 specialists around the country, special needs specialists with Northwestern Mutual, and we have an agreement with National Care Advisors that they give us about 2 to 3 hours with any given client that you wouldn't have to pay for, that we have a good conference call and some good follow-up and directions on things. And it's resulted in folks getting their Social Security benefits raised. It's resulted in folks getting more hours of care through local waivers. So a combination of working with local folks and our group nationally has been real effective, because on the financial side, I'm pretty solid and on what needs to be done from an estate planning perspective, but I'm not the top-notch expert on every government benefit out there, so I certainly use people who are educated on it better than I am as partners to get those things done. So really, I think it's just about, again, imagine it. You got to sit down, you got to implement it to get it done. The only thing I think I missed on this packet that I said I was going to talk about was the letter of intent. So that's the last thing in the packet. I think that would be interesting, especially the folks that have a special needs child. If you don't have this as part of your estate plan, you'll want to look at this, and you probably will end up wanting to fill this out and just putting it, you really just need to put it with your estate planning documents in a safe place. So when that time comes, this will be there with the other estate planning documents. And whoever that caretaker is going to be for that special needs child has some really pertinent, key information that, again, is not going to be in a will or a power of attorney or a trust. It's not going to be there. Okay? Any questions? I know I want to let the rock star get started.